Welcome to Bad Law, Worst Facts. I'm your host, Michael Tekla. Today we have on Shane McGuire. He did something that I think is super interesting. You took a default judgment from a previous attorney where C. Harbor decided not to show up to the trial. And instead of trying to settle it from a Stowers situation of $500, you went and got a $2.5 million settlement. Shane, how are you doing today?
I'm doing great, Michael. I was so pumped when I got your email reaching out to me. Thanks for having me.
Of course. I really like this story. Tell us a little, tell the viewers a little bit about, how this came about, and what your thought process was.
Your pod is really, I feel like, geared to young lawyers, right?
Yeah.
And I'm gonna back up a second and tell you just a piece of advice for young lawyers is this: be nice to other people. Okay. Every business is a relationship business. And so this case comes to me from a guy named Jeff Hoover, who's a good friend of mine. And I did insurance defense work for years. And I had a number of cases against Jeff before I went out on my own and started doing plaintiff. And so when I was on my own years ago, I sent him a case or JV'd it with him that it actually we settled it for $2.5 million. And just joint ventured it 50-50. And it was an odd case. It wasn't a trucking case, but it had just real great facts to it and, a good pool of money to get. And so this case originates, if you could really back up from just having a good relationship with somebody who used to be an advocate. Okay.
Right.
Now, I'm going to tell you the story of this case. This is, Michael, it's Rumpelstiltskin. It's turning straw into gold. But you got to be creative and just be willing to take risks and turning in that. So here's how it happens. So Jeff had just a simple car wreck case. He had two clients hurt in a car wreck by a drunk driver. And his clients were passengers in a vehicle. The driver of their vehicle never made a claim, wasn't hurt. He got the passengers. Passengers Cairo only. One had $9,000 in change in medical. The other had like 15 in medical. Just all Cairo. C. Harbor insures the defendant, the drunk driver. And C. Harbor assigns the case to outside counsel. They work the case up, take depots, etc. Hoover sends a Stowers demand, it's 30-60 policy. I'll settle plaintiff A for 30. I'll settle plaintiff B for 30.
Right.
And C. Harbor offers 13 on one, and 8, the numbers, but under 15 on one of them, and under 20 on the other. Okay. And it's like, okay, let's go try that case.
Yeah.
So eventually, C. Harbor as a business model decides to save money by not having outside counsel, pulling all the counsel in-house, having staff counsel. I hire a guy from Illinois to manage it, and they hire,
Oh, no.
I'll just say lawyers of varying quality to staff the staff counsel.
Sure, because they're not billing by the hour, they're billing by the case, right? So.
Yeah, and honestly, I mean, would you want to be staff counsel at an insurance company?
No.
It's
I have friends. I have friends who do it, and from what they tell me, the benefits are great. But for me, I think that'd be a 0 out of 10 experience. But to each their own.
The benefits are great. One of the lawyers, but before, just at some point, I talked to each lawyer who had been a staff counsel, almost any lawyer who had touched the file. And one of them had actually gone to Penn State. She was smart. And she said, I bet you're wondering why I'm working for this crappy insurance company. And I was like, well, I wasn't going to ask. But and she said benefits. But she had an illness and she needed, health insurance and not the grind for a season until she recovered from that. And now she's better in private practice. But yeah, I think a lot of people take the job for the benefits. It's a thankless job. So anyway, so C. Harbor takes all their counsel in-house. One of their in-house counsel agrees to a trial setting. And they agree to a trial setting in Great County, and the staff counsel are all in Dallas. And they have pre-trial hearing. Staff counsel doesn't show up. And it happens that I had a case against C. Harbor at the same time. And so Jeff and I were talking about, hey, you heard of the C. Harbor insurance? What are they doing? Somebody no-showed at a motion for sanctions hearing that I had, in Smith County. This lawyer, it was a different lawyer, but no-showed. And anyway, so it was a total cluster. And so he says, hey, this lawyer no-showed at pre-trial. I'm just going to lay in the weeds because it's an agreed setting. See if they show up at trial. Defense lawyer no-shows at trial. Defendant no-shows at trial. Jeff says, hey, I'll waive my right to a jury. and I'll present this evidence to a judge. Nobody there to object. And on $9,000 in Cairo, $14,000 in Cairo, he gets a judgment of $500,000. 200 of which, and I'm rounding the numbers here, but 200 of
Sure.
200 of which is exemplary because it's a drunk driving case. And as you know, exemplary damages, especially in personal lines cases, they never want to pay them.
Of course not. Yeah.
So he has a $500,000. And so he decides, okay, I'm going to wait for the appellate deadlines to pass.
Absolutely.
So Sea Harbor, at this point in their story, they're eliminated. They realize they've screwed up. In fact, Daniel Stark at some point had an excess verdict against them. Not a massive one, but a real trial where somebody shows up and there's, a verdict in excess in policy. And so now they're, okay, we're going to hire outside counsel to go dive in on these cases. They find this one in their case list and like, holy crap, there's a judgment. And so they have a guy, outside counsel in Houston, file a motion for a new trial.
Okay. Expected.
And typically that's a laydown if you accidentally don't show. This
Right.
judge, his reason for why we need a new trial is we didn't get notice. And his claim for didn't get notice is that the Sea Harbor employee lawyer didn't calendar. Now, who knows if that's really true, but that's what he said. She quit in the meantime, and she didn't calendar a judge, so give us a new trial. And so Judge was like, they can say a lot of things, but they can't say they didn't get notice. I mean, her email address is at Sea Harbor Insurance.
Right.
Their employee got notice. So judge denies the motion for retrial. The appellate deadlines are starting, so then you restart the deadlines. And that defense lawyer never tells the insured there's a judgment against you. Never calls her, never says, hey, the carrier screwed up. What he does is he drafts a letter saying, hey, there's a $500,000 judgment against you. You only have $60,000 in insurance. And
Good luck.
And they fulfilled their obligation by writing checks, be warm and be fed. She never even gets the letter. He sends it certified to her. She's like, we're, a year removed. So, but
at that point in time, do you just start sprinting to your legal malpractice office? Like I don't think a letter is quick enough.
God bless him. We didn't make a legal malpractice claim against him.
Right. That wouldn't have, that was your client, right?
She's been compensated.
Right.
The damage is already baked in. I mean, anyway, so all that to say, so at this point, I don't have the case. Okay, so Jeff, the original plaintiff counsel, talks to new defense counsel, who I'm not going to name. I don't want to embarrass him.
No, of course.
So he talks to him and says, hey, have your insured. She needs to hire a lawyer. Have her call Shane McGuire. And of course, we've been talking about this case. All right. The talk is, how do you get a $500,000 judgment? And how do you make it into something bigger? Because what's better than getting $500,000? Getting more than $500,000. Okay. So how do you
That's
do
fair.
Like, what's the goal? Is the goal, because you can get to 60. And you know that you could probably hold their feet to the fire and maybe get, the non-punitive component of the damages, maybe get 300.
Right.
If you really want to risk it, if you really want to go, maybe you get the 500, or you can try to be creative and try to build it, see what you can do.
So that's the reason why I read your post and I was like, this guy needs to be on my podcast, because I thought it was really interesting. I think there's one of three options. People will say the business route, quick money, get in, get out. If they send you the 30,000, take it, move on. Right, low level.
Yeah,
I don't think I would have done that. But the second one is, well, you've got a judgment. Make them pay as close to the judgment as possible. I don't think the appeals deadline is passed, so I don't think they don't have very much room or argument. But they can make some coverage opinion or something like that. You may settle around there. Either way, that's a good win for your client. But you did number 3, and I thought that was very, very interesting. So talk to me about what was your thought process? It's essentially you're using the Stowers Doctrine to get there. Is that right?
Yeah. So let me tell you what we did. So first of all, in that period before the deadlines run, he sent him a demand for, if you want to pay it, we give it a shot. And they didn't pay it. What they did, and you're going to love this, they sent 2 checks for $30,000 each and said, paid it settlement,
Yep.
And so So that's an important point, and this leads to what we did. So I signed the client up. After the deadlines have run, I meet with her and I sign it up. And here are the causes of action we want to bring. One, you've got just a deck action, straight up deck.
Right.
The policy says what it says. You failed in your duty to indemnify, and by the way, your duty to defend. In these, all right? Because what the carrier would say is, it's not that we evaluated it wrong; it's that the lawyer didn't show up. And but they own the lawyer. The lawyer is an employee of theirs, so they can't give up. Deck action on duty to defend, duty to indemnify. We also have, just a Stowers claim, which is really a negligence claim. All right. But if the insured is the one bringing the negligence claim, she can bring an exemplary damages claim because it's grossly negligent.
Okay. That's
You tell me who I can. I mean, there's not something that says she can't do it. So that's what we do. And we filed in a DTPA action. You sold us a product. Okay. You made certain representations to the consumer. You made a representation that you owe this policy. One of the things I'm buying is you're going to indemnify me for a loss. You're going to provide me a lawyer if I go to trial in this case. And what you sold me didn't have the benefits that you said it would. Okay.
It opens up treble damages. It opens up a whole slew of new, I would say, numbers on the jury verdict, essentially, at that point.
And what DTPA gets you to is you get treble damages and you get a blank for middle anguish. And what the real number would be on middle anguish. But my client worked at the Smoothie King, and she's got a $500,000 judgment against her because of the malfeasance of an insurance company. She's a pretty sympathetic person, okay, in this. She was a drunk driver, okay?
Right.
That's the thing that you don't like. But, she's admitting it. What are you going to do? This is why she has insurance, and God bless the underlying plaintiffs. They're not hurt that bad. They should have paid.
I got two questions here before we go on. So first, that is a lot of Smoothie King. That's a lot of smoothies. But no, what was without getting into attorney-client privilege, the thought process, was she pissed? I mean, was she just completely irate that this had gone so far and that there was simply a verdict against her? Was it because, look, every attorney's like, Stowers, throw up our hands and scream at the top of our lungs. But you have to keep in mind, you have to get the assignment from the defendant. And so it's kind of like, how do I do that? So I'm just curious, when you spoke to her, was it like, yeah, this is absolutely terrible?
So the beauty of that, yes. So Michael, here's the thing. We didn't do an assignment.
Okay.
I view the assignment of the claim as a damage limiting move.
Okay.
So damage limiting move. And here's what I mean by that. He's got a $500,000 judgment. If my client had assigned that $500,000 judgment, the Stowers claim from that to the underlying plaintiffs, their claim against the carrier is worth $500,000.
Right.
It's worth $500,000.
Okay.
Even if damages, they're not a consumer under DTPA. It's just that she's assigning a Stowers claim. The trick was, and this is the key, the underlying insured had to be the plaintiff. That was the
right.
Okay, she's the plaintiff, which means she's going to get some compensation. All right. But it also means you're going to elevate the compensation that the underlying plaintiffs get as well. Okay, because really at that point, you're working together to try to hold the insurance company accountable. But you asked how she felt about it. And I did insurance defense work for several years. And I can tell you what insurers think about these cases. Typically, a lot of times they think they're not the fault. Now, this one, she was intoxicated. So what are you going to do?
Right.
Now, every insurer who gets sued wants the case to just go. That's the goal. If they have to go try it, they'll be bought in. They'll try to win. They'll be pot committed. They feel like somebody's coming after them, even though it's insurance money. And they'll try to, most of the time, if they show up to trial, they're trying to help their lawyer out.
Right.
But what every insured wants is they want the case to go away. And so what she was mostly upset about was she'd been taken advantage of. And she really had been taken advantage. So here's the deal with her. The only time she's contacted is to give her deposition. That's it. Maybe to respond to interrogatories, but they're sending status reports to the insurance company. They ain't texting her. They're not emailing her and saying, hey, we're still working on your case. Like when you and I have a case, our clients, they're going to text us, they're going to email us, they're going to reach out to our assistants or staff. What's going on with the case? Insurance don't do that. They're just home and they don't want the case to interrupt their life.
Right.
What happens with her is some guy calls her and says, hey, there's a $500,000 judgment against you. And by the way, because she's intoxicated, she can't just discharge it in bankruptcy. It's not going to work. My recollection of the bankruptcy code is there's an exclusion for if you have a debt due to personal injury caused by intoxication. Okay, you can't discharge it.
That's interesting. Okay.
I have to go back and look. But I think that there was some hook where she couldn't discharge. So she was stuck. And so here you have somebody working minimum wage-ish, okay, who can never pay $500,000 on anything.
Right.
And she pays for insurance every month because the law requires her to. And here's these people who screwed her over. And now they're saying, hey, we've done our duty. You get $500,000 against you. Okay. So she feels taken advantage. So part of the deal is when she reached out to me, even though she called me, I had to build trust with her because her only experience was 3 lawyers, none of whom she ever met, who screwed her over on behalf of the insurance company. That's all she did. I'm the 4th lawyer who's ever represented her. But now it's like real representation. It's me and her.
Right.
I drove to the town where she lives and met with her at somebody else's office and just sat down with her and walked her through it. I said, hey, we're going to be joined at the hip for a period of time, but you're not going to have to write me a check. You're on a contingency fee, and we're going to get this judgment, wiped away. And I'm going to do everything I can to put some money in your pocket on top of that. Okay, that's what we're going to do. But let's talk about how to take $500,000, and let's talk about how to make that 2.5. The insurance company didn't think we could do it. Their lawyers didn't think we could do it, but we did. And so it took a couple of things. So I mentioned earlier that the first thing the carrier did after the judgment was they sent 2 checks to the underlying plaintiff lawyer for $30,000. Now, as you know, Michael, on a DTPA action, you've got to wait a certain number of days after you send a notice letter to file suit. So Sea Harbor is based in Dallas County, which is a good county for a plaintiff. My client lives in Harrison County, which you may not know as Marshall. That's a good venue for a plaintiff. The underlying case was in Gregg County. So here's what we did. I sent the DTPA notice letter. Underlying plaintiff lawyer gets these checks in the mail. What he does is he files a deck action on those checks in Harrison County. Judge, look at these checks. Look at these checks. Look at the judgment. Tell me I can deposit these checks and just get a deduction off the judgment and not the judgment.
Right.
I filed a deck action in Dallas County just on the policy language. All right, just as a placeholder, so that I can go ahead and get discovery going. I can send a request for deposition. I can have some teeth to exfoliation levels. All right. Now, in the meantime, I'm calling every lawyer who's ever touched the file, and they all uniformly tell me that Sea Harbor doesn't know this. That it's actually nobody has authority to do it. In fact, they told me that to get limits on a claim, you needed the owner of the insurance company's approval to pay $30,000.
That's ridiculous. Okay.
The adjusters had, I forget what the number was, but it was like $5,000 in the thing, $10,000 in the thing, some low number. And they only write 30, 60 policies.
Right.
And so you want 30, the owner of the company has to bless that 30. That's bananas when you're talking about writing coverage all over the state. So here's what we did. We have 2 deck actions pending at this point. One in Harrison County on the checks that he's filed, and one in Dallas County on the judgment and the policy that I filed as a placeholder for the future DTPA. So while these are holding, when you file a deck action, you have to name everyone who has an interest in the claim.
Sure. Yeah.
If he files his deck action in Harrison County, my client's a defendant because she has an interest in it. When I file my deck action in Dallas County, I have to name the underlying plaintiffs as defendants because they have an interest in it. And now what do you have? You have both lawyers aiming right for it. All right. And you have to have the cooperation. So here's what we do. We say, you know what we need first? Now we get 2 cracks at depots. We got 2 cases pending. Hoover's going to take cracks at depots in the Harrison County case, and I'm going to do it in the Dallas County case. That frees us up to get depots before you spun your wheels on written discovery too much.
Sure.
Because you can go ahead and talk about it, do some exploring. So the Dallas County case and the Harrison County case, it's the first depot we took. We get the deposition of the owner of the insurance company to take place in Longwood. Michael, what's the first thing you say in a depot? Like, what's the first? I know you have like a routine we all do. Like, what's the first?
Yeah. Could you state your name for the record?
Yeah. So I have to give it to him. So I'm sitting on that. He took the lead on that depot. The first question he asked was, "Is it ever okay to defraud or swindle someone?"
God, I think if I was him, I was an opponent, I'd be like, it's going to be a rough time for me.
Okay, and we created at the end of the case. Can I share the screen? Do I have that ability?
Sure. Yeah.
Oh, it's disabled. Can you undisable it?
Yes.
Okay. So by the time we mediated the case, we created some boards with just one of my staff members did this, Erin. She did a great job. Created a couple of whiteboards with just pictures of the deponents along with some language from the depots. And this, what you see at the very top here, do you agree with me that one person should not try to defraud or swindle another person? His answer was, I don't know. Okay. So he had probably been prepped on, like we prep our clients, they're going to start with you, say your name and who you're related to and where you work and all that jazz. And we had really gamed this out, that we were going to walk in and try to attack this in an unexpected way. And the question of, is it ever okay to defraud or swindle somebody, was so shocking to him that he gave us candid instead of a rehearsed answer, which is, I don't know. Now, you're going to love this. You probably look up all the, I don't know if you have Lexis or Westlaw, but you probably look up all the, your defendant or whoever.
Right.
Okay. Well, this guy, owner of the company, lives in Dallas, but he used to live in Illinois. I looked him up on Lexis to see if he'd ever been sued before. Now, the theme of my case was that there's a reason why he's refusing to pay out claims. You got to build a story, right? You got to have a narrative. Right. And the narrative is they're preying on poor people, which is really what they do. It's trash insurance. So they're preying on poor people, thinking the poor person, unsophisticated, is never going to do anything about it. That's what they're banking on. And so you have to make it really clear. You have to have a bad guy, and you have to make it clear that they're doing something. Like, what's the intent? Why are they doing this? Why are they not pay? Why not pay $30,000 on 15 in medical on a truck driving case?
Easy, right? Any other insurance company would.
Sure, even Allstate, they're going to pay that. I looked them up on Lexis, and I found a divorce proceeding, an appeal in a divorce proceeding in Illinois, where his ex-wife was like, why am I not getting the money I think I ought to get?
Sure. Okay.
Why didn't you claim that Porsche in the driveway as part of the assets? Why didn't you claim that Range Rover as part of the assets? And why are you taking your new wife all over what is this? How come I feel like I'm not getting enough? And the appellate court characterized his arguments, this guy's arguments. His argument was, that's not my Range Rover. That's Sea Harbor's Range Rover.
Right.
That's not my Porsche. That's Sea Harbor's Porsche. And my new wife shopping trips, that's not. She's an employee of the company, and that's how she's compensated. She's not on the payroll, but we get compensated by flying all over the country, doing shopping. That's an appellate opinion in Illinois appellate court. Okay. So we're asking him these questions. I mean, can you imagine? Can you imagine sitting there watching your client? Because they don't know.
Right.
But our argument is, this is really your piggy bank. And what you're trying to do is just make sure the piggy bank's as full as possible so you can keep rating it. That's why you won't pay simple claims. Okay, so that's what we get out of first deposition is Hoover, and I asked him some questions too, but he takes the lead on that. Then with the Dallas County case, go ahead. Do you have a question on it?
So is the question about veracity, is that in the case of Don?
Both of them. So we can pull that up again.
Yeah,
So,
I really like that question. That's
oh my gosh, it was so funny. So I can't remember if I asked this because we both took a crack at him. At one point, and I didn't even put the question there, but either I or Jeff had used the word veracity, and he said,
sure.
Yeah, you lost me on veracity. Can you reword that? And I just said, that doesn't surprise me. Veracity. So then I took the deposition of the chief of claims for the Dallas County case. Listen, this is a 6-hour depo. This is all day.
Right. And
so one of the questions I asked him was, let's see.
The pictures, man. You picked the best unflattering pictures.
Well, that's my staff. I mean, they spent hours doing that.
Right.
And I just asked him, do you know what the word veracity means? And he said, no. Now, you give me, now this is a guy who makes $250,000 a year as chief of claims for an insurance company. You know, the other guy, you know, multi-millionaire, owns an insurance company. You're going to tell me you boys are going to roll in to this case and act like you don't know what the word veracity means. I mean, that's not an SAT word. That's my 13-year-old knows what the word veracity means. Anyway, okay, so we take the owner's deposition in the Harrison County case, and what we establish out of that is that I think we get like the business practice, you know, bringing the lawyers in, how it's managed, who has to approve Stowers claims, things like that.
And you get a real peel behind the curtain look of how this insurance company is run.
Yeah. And something that, and I don't know how many people know this, but you know, you've seen insurance policies. Do you know what an MGA is? Do you have any idea? Yeah. Okay. I think a lot of people don't know this. So if you see a crash report with old American, you see a crash report with Red, those are like the real carriers. The real carrier is somebody me, and it'll be somebody like 21st Century, Marshall Services, or you know, Sea Harbor Insurance, or whatever, or Diamond Specialty, who's writing under somebody else's paper, right? And they're called MGAs, Sea Harbor, MGA, Managing General Agent. And so they write the policy under Red Point paper, and they handle all the claims, et cetera. And so we got you know, some insider info on from talking to him. And what he said was that their policy, when they get a Stowers to is they forward that to Red Point. They were writing under Red Point. Who did you forward it to at Red Point? Two guys, the general counsel and the CEO. You know, I think one of the witnesses said just the general counsel, and one guy said the general counsel, the president, or CEO. Okay, great. Why do you send it to them? And the Sea Harbor owner says, well, we have to have their approval to pay that, which cannot be true.
Okay. It doesn't make any sense. Yeah.
The GC at Red Point said it's not true. Privately, he told us that. Like that's ridiculous. You know, they can pay. They need to send it to us, but they need to send us the Stowers. It's, you know, they're the ones evaluating.
Right.
Okay. So, in one great thing, just some color to this, is the president of Red Point teaches risk management at UT Austin. And, yeah, and so they knew, and the president of Red Point, I mean, Red Point didn't pay us anything. We had to name them too because they're on the policy. And I told, you know, we had a pending request. I wanted every exam, risk management exam, that this guy had ever submitted at UT Austin, just so I could use it on this case, because he was going to be my best witness. He was a lawyer by training in risk management, just walking through as a lawyer, should you show up to trial? Talk to me about that. So with the chief of claims deposition, it was interesting in that the chief of claims said that it is their policy to pay excess verdicts. There's a verdict excess policy, we pay. And they did. You know, they had two opportunities to pay the excess verdict without me suing. They never did. And so, you know, what they wanted to do, they had, and this is kind of funny, they had their own insurance. They had an E&O policy. And I love that this happened.
Insurance company has an insurance policy as well, too.
They had an E&O policy.
Okay. Yeah, makes sense.
In just like some form of cosmic comeuppance, their insurance carrier said, this is not an E&O claim. This is a legal malpractice. Your lawyer didn't show up to trial. That's the problem. And so they had $1 million in insurance for E&O, which is a lot on a 30/60 company that sells 30/60. They shouldn't be able to mess up $1 million. Hey, they would never pay their full policy. Now, we didn't care where the money came. We're just negotiating straight up numbers. All right.
Sure.
And so they would never tender their full million. So they paid $500,000 out of their policy at the end of the day. And it was just kind of beautiful on the day of mediation to see the bad insurance company, Seahawk, complaining and just moaning we mediated this thing from 9 in the morning to 9:30. Okay. And the whole time they are just griping that their carrier won't step up and do the right thing. Can you believe that? Really sorry.
It's like that pirate meme where it's like first time.
That's right. That's exactly right. So it was a lot of fun. It's a lot to take in, but it was a fun case. And the thing is, and one of the fun things about it is every defense lawyer who would touch that case from the beginning, it screwed it up. They all screwed it up. From the first outside counsel who was assigned to the staff counsel to the second outside counsel who was assigned. And we were standing outside after a hearing, a discovery hearing one morning in Harrison County. And an associate had come out to argue whatever motion to call it that. And of course, we won the motion. And we walked outside of that courtroom. And I told him, hey, listen, you need to go tell the people they're going to have to pay us over $2 million in this case. And he said, I don't see how you're ever going to get to $1 million. I said, hey, just watch. I mean, it's pretty simple. I mean, I think it's a pretty easy DTPA case. It's not a DTPA case. It's a gross negligence case. I don't think it's going to be that hard to get a jury to award punitive damages, triple damages on this case. I'm good at doing it.
Yeah.
And what y'all have done is taken a case and you could have settled it for 60, and then you could have settled it for 500 right after the verdict or the judgment. But I'm telling you now, it's going to cost you over $2. And take it for what? And he was ridiculous. He goes off and says that I'm absurd. So it's gratifying at the end when you kind of call your shot a little bit. Okay, thoughts. It's so haphazard. Like there's like 3 underlying cases.
So I think it's really interesting. The one thing that, man, it's hard for me to create a damage model like that and then stick it out. How long did the case go for?
Hey, the underlying trial was February of last year.
Wow. Okay.
Yeah.
That's
okay. Appellate deadlines run maybe June after the motion for new trial.
Sure.
I'm going to mess this up a little bit, but
right around there. Yeah.
I bet I filed it in July of last year. And listen, to do this, Michael, it takes teamwork between the original plaintiff lawyer and the lawyer who's going to represent the defendant in the underlying case. Okay. You have to work together on it and trust each other that you're both going to make more money at the end of the day from this whole down. Because they're going to figure out at some point that they're screwed. And so here's what happened in our case. At some point, I had I don't remember what the demand was. I had a demand of $3.5 million, $4.5 million, whatever my demand was last fall. While that demand was pending, I mean, at this point, Sea Harbor they have real lawyers representing. They have good lawyers in the state. And they reach out to Hooper, the original plaintiff lawyer, and they say, hey, what's the amount of the judgment? Here it is. With interest, it's now this. And so they try to go pay the judgment to undercut the DTPA. What they're going to try to do is take out my damage.
Right. Can't anchor it to the chain anymore. Yeah, makes sense.
All right. Yeah. I view this is very similar, honestly, to when the carriers try to buy your medical.
Yeah.
Right? You still get to post it. Like if that happens to you, you still get to post the medical lien, but on the medical bill, but on the back end, they get an offset. Whatever. Right. That's the way it's. And that's what I told them. I said, listen, you can send a check for that. But 2 things. 1, that's still going to be my lodestar. It's still going to be the basis I'm going to jump off. 2, my client, the underlying defendant, my client is who owns the Stowers claim. You owe that $500,000, not to the original plaintiff. You owe it to my client. She can pay him or not pay him. But my client has the claim. And by the way, the only reason you're writing that check is because I have a demand out to you right now and because I'm suing you. And by the way, I have an attorney fee lien on that check because you're writing it because of the work that I'm doing. So I called underlying plaintiff lawyer. I said, hey, this is the way we need to do it. They said, I agree. Let's do it then. So they had said they're sending that $500,000 check. I sent an email saying I've got an attorney fee lien on that. I'm instructing Mr. Hoover to send me that check as soon as he gets it. Mr. Hoover sends an email back to everybody, says, I agree. I think there's an attorney fee lien on it. I'm going to send it to Mr. McGuire when I get the check. So he gets the check in, sends it to me, and I put it in my holding. That's where we got the first $500,000. And we said, hey, if you want to file a deck action on that, let's go do it. Let's see if you can find a sympathetic judge on your scheming around by pending demand. Let's go do that. Throw me in that briar patch. And so
yeah.
Go ahead.
I'm just curious. You start off with two $30,000 checks. Now you've got 500 plus check, whatever that Tristan came up with. I mean, at this point, you're like, are you checking the mail every day to see if there's more bigger checks coming in?
Strong the goal. You're taking a 30-60 case, and the goals. What can we do to make this a multi-million-dollar case? Because I've never heard of somebody doing it, but we're going to try to figure it out. Hey, so that was maybe October, November-ish that they paid that $500,000 of last year. Hold it in trust. Okay, it's there. And, I have an agreement with them. They're not going to try to execute on the judgment against my client. And we go mediate the case. And, the rest is history, as they say. We were going to hold firm at $2 million. I wasn't going to settle for less than the additional $2 million.
Right.
And got it done. And hey, you're going to love this. The check I got, handwritten. When's the last time? Have you ever gotten a handwritten check from an insurance company?
I'm not.
That's my only one too. I mean, it was on the Sea Harbor, check, but instead of running it through the printer, he wrote it out.
So did his wife sign it, or did he sign it?
She was a signatory on the account.
She's not an employee.
We asked him who all are signatories on the Sea Harbor account. He said, me and my wife. We're like, okay, all right, buddy. It's family business.
Yeah, that's ridiculous.
Yeah.
That is. So what I like I said, what I like about your story is it takes a 30-60 case.
Yeah.
Now, to be fair, you didn't have to deal with it's a soft tissue injury, all that. No. There was a mistake by the insurance company, and you capitalized on it. Then you had a choice to make the first business decision. You said no, right? There is way more at the end of this. Second business decision, no. And to figure out a way to pot of $2.5 million on a case that should have been settled for, without you involved, 60 and moved on. At what point in time did you say, yeah, I got to be careful. If I push too much, this may just crumble?
So when you're dealing, okay, that's a great question. One, you can never forget that you represent a client.
Sure.
At the end of the day, it's not about Michael Tokla hanging, a trophy on the wall.
Right.
You're representing a client. And I'm putting, this number puts life-changing money. I felt confident in the case that at the end of the day, on the low end, I could get $1.5 million. And you can have a rational confidence about your cases.
Sure.
But
do it all the time.
Hey, I know. But the facts were so bad.
Yeah.
And here, okay. The risk on could it crumble, because that is something that you had to consider. Here's the risk, and I'm going to tell you what militated against that and made it not crumble. The risk on could it crumble is that it really was that dude's money. Like when the insurance company is owned by a guy, it's his money, and I don't know how much you have to be worth. I mean, of that $2.5 million, $500,000 was their insurance, and $2 million was. I don't know what you have to be worth before $2 million isn't a lot of money.
Sure.
But it's a big number, right? Like if you're worth $10 million, $2 million is a lot of money. If you're worth $20 million, $2 million is a lot of money.
Yeah. And then worth, when people say worth, that doesn't mean you're liquid for that amount, right? And so to be liquid for $2 million at any point in time, especially on a claim that was messed up and you have to go pay it with a person or with a written check.
Yeah.
That's tough.
Well, yeah, there's going to be some line of credit or something. So
sure.
So the thought was the risk on could it fall apart is at the end of the day, there's a human being who's taking a hit $2 million.
Right.
And there is a number at which he's just not going to take the hit. He's gonna roll the dice.
Right.
Now, especially since, his insurance company's providing his defense. He had personal counsel too, but he can ride the insurance company's defense a little bit so that there's not, fee pressure each and every month.
Sure.
Now,
Absolutely.
that was the could it crumble. Here's the thing though that gave us confidence that it wouldn't crumble. You have really two big carriers in Texas, the MGH, Old American and Redpoint.
Right.
And Redpoint, Old American, they got 1,000 MGAs filing with them. They don't need Sea Harbor. Sea Harbor has to have Redpoint.
Yeah.
So we named Redpoint as a defendant. Redpoint's GC is a really nice guy. Their GC is all the depots. He's at mediation. He is involved. He is the equivalent of this of having personal counsel put pressure on the carrier to pay Stowers.
Sure.
Like when you're suing like XYZ business, sending stuff to your personal counsel, and that guy is supposed to lean on the carrier to pay. That's what the GC of Redpoint was doing. He was leaning on him to pay. And so I don't know what the ins and outs of that conversation were, but my theory on it was that Redpoint can cut him off. They can say, hey, listen, you can't ride under us anymore because y'all are getting us sued when you just need to step up and pay your issue. No, we're in the risk elimination business, not the risk creation business.
Sure.
So
maybe get in the water.
Right. Yeah. So my thought was, yeah, I'm putting money pressure on them, but Redpoint can put existential pressure. Like you don't have a company anymore if you can't write under us. And it may take them a while to go write under some other company. So that was the theory. Redpoint had to be in the case because they're actually the ones on the policy. It's a Redpoint policy, with Sea Harbor as the MGA. So we got to sue them. But it turns out, if you really tease it out, it's Redpoint that's going to put the fee pressure on them, or put the pressure on them that they have to pay. If they don't pay, they're going to cut them off. That was the theory. And I think at the end of the day, that's what happens. Redpoint's there the whole time. Okay, hey, get rid of this case.
So if you could give, like a young attorney kind of one takeaway from this, what would it be? Besides, think very carefully about your moves. I think I would have done an assignment. It's good to know that I'm good. I'm not in your position. And it's good to know that that's not always the just immediate, flick to do.
I mean, it was a unique set of facts.
Sure.
But one piece of advice, distill it down. You need to have people in your life that you trust. Yeah. This doesn't work unless Jeff and I trust each other.
Yeah. And
can you work together to build something? And you know how it is, like, the difference between being on a team and an individual sport. The team helps pump you up. And so we didn't have like a formal JV agreement or something like that. It wasn't formal. But we're there pushing each other to build up the value of the case. So you have somebody you trust. And the second thing I would say is be creative. Just because everybody else is doing it a certain way doesn't mean that's necessarily the way to do it.
Sure.
Because the reality is, like we talked about earlier, maybe it was offline. How many people really bring a Stowers case?
Not very many.
Man, it's
not very many. In fact, there's so few that the one that I know of has been on my podcast, Hussein Hani in Montgomery County. And that's only because Geico thought there's no way you're going to win in Montgomery County on this. Go ahead.
And so my thought on it was, if you really just tease it out, the person who the insurance company wronged is not really the underlying plaintiff, it's the underlying defendant. Yeah. And so if you were going to trial, who is the jury going to be more sympathetic to? If you were to really try the Stowers, who is the jury going to be more sympathetic to? And there's the risk that, the underlying plaintiff lawyer can come up, he's trying to capitalize on somebody else's fault. His clients are falling on this thing. But if you have like insured, everybody in the jury is an insured.
Yeah.
Everybody on the jury. But I was going to say, they either have car insurance or they say they have car insurance. It's going to be.
They're not going to lie in the jury box for sure.
Yeah. And so, if you say, hey, I'm sorry, caused a wreck, but this is why I have insurance, and this is what they did to me.
Sure.
Jury's going to line them up on that. And there's value in it. And so if everybody can, in our situation, we made it to where everybody made more money by the underlying plaintiff, the underlying defendant bringing the Stowers. Because, I don't think that the underlying plaintiff can really successfully bring a DTPA, even with the assignment. And I don't think a jury would ever give them exemplary damages on assignment. I don't even know if you could get that.
I don't think, I don't think you can.
Yeah. And so here we have 4 defendants who we sued, and my client can, say that each one of these 4 defendants, 2 carriers and 2 individuals, each one of these people has wronged her and has caused her to have this judgment against her. Jury hit 4 people for exemplary damages, $200,000 apiece. It instantly just really elevates your potential damage. And, you add a little mental anguish on it, some attorney fees on it, as blanks that you get to have in the court, put some pressure on. So it was fun.
That's really interesting. Well, look, Shane, I appreciate you coming on. I mean, you gave us a good story. I like this one. If someone wants to get in contact with you to work on a case, because apparently if you don't go full assignment with Stowers, there's definitely another avenue with a specific set of facts, of course. How can they contact you?
McGuirefirm.com. They'll find me. I'm in Tyler, Texas. East Texas is my home. I love it out here. We'll go wherever, I guess, but I prefer East Texas.
Absolutely. Well, you never know. My podcast is pretty popular in the Houston and Harris County area and Dallas. You may get some calls. You might have to come down.
Well, hey, I'd be happy to. The beauty is, it's a fun way to run it. And, with insurance companies, Michael, here's the thing. Okay. And I know that you're doing an ending there, but I'm going to throw this at you. These insurance adjusters, like, they're sitting in a cubicle all day, or now I guess they're maybe at home.
Yeah. And
they're looking at the same thing over and over. They're looking at what's a sore back word, what's a soft tissue case word, what's a neurotomy word, what blah, blah, blah.
Right.
There's not an adjuster who has worked a case where their insured has sued the carrier because the carrier screwed up and let a verdict come in over the policy. Those adjusters aren't out there. They don't know what to do with it. And everybody gets into preserve their job mode. Okay? And that creates fear, and that will increase the value you can get at the end of the case. And so honestly, there's some Stowers cases, if you got a 30-60 policy and you come in and you get it for 50, they're going to pay you the 50. They're going to pay it, and they ought to pay it. And my view is if you tag them with an excess verdict and they pay that verdict, hey, that's it. You win. If you get a verdict and they say, hey, listen, we're just going to give you the policy, we don't think you have a Stowers claim. It's at that point that you need to look to the insured, the underlying defendant, hiring counsel themselves. That's the person that should call. Okay? And if that person brings their own claim, they can work with the underlying plaintiff, and rising tide lifts all boats.
Absolutely. No, it's like I said, I've said it a few times, right? It's just super interesting that you took it this way. And you're right. I mean, they may even pay you before a verdict. They may pay you at mediation if you can prove that something's been wrong and that's going to be a problem and there's a whole bunch of bad issues or bad facts on their part. But if you're able to get something and you can do it that way, you've just opened a door to what I think is a significant liability, like very significant.
Yeah.
So it's very interesting. It is. Shane, I appreciate it. Thank you so much for coming on, and we'll talk soon.
All right, Michael. Thanks, buddy.